Hand over this.
My lord, may I be allowed to pray for leave to file with a server copy, my lord? My lord, order.
The urgency.
My lord, the urgency is, my lord, on 3rd it is fixed for recovery of possession by bailiff, my lord. My lord, order of 12th, my lord, applied on 8th.
My lord, may I?
Extension. Yes.
My lord, may I permit it?
What do you want?
Number of adjournment. Well, your lordship kindly.
64 of the days list.
Yes, sir.
What do you want? Upgradation.
No, if your lordship can take it.
Yes.
My lord, may I permit the application?
Hold on, serially.
Application for recalling. Application for recalling the order of the.
Fine. Yes, call the list.
Returnable tomorrow, your lordship.
Yes. Nothing will happen. Yes, call the list.
Item number 1.
What do you want? Upgradation. Yes, call the list.
My lord, I am for the petitioner, my lord. My lord, it may be released in terms of this order, my lord. Similar revisional application was filed, my lord.
Substitute order. The earlier order was challenged. My lord was. Yes. I am ready for the.
Has been sub. Yes.
My lord, that is I.
I think, lordship, just now I have received the copy, lordship. Kindly allow me 1 day time, lordship. Just now I have received the order.
Can you not come at 2 p.m.?
2 p.m. Lordship.
I have some difficulty. Division bench is there.
So they have juniors assisting you.
See the paragraph 4 of
She wants to go through that. I'm taking it at 2 p.m. What tomorrow, whatever is convenient to you. 2 p.m.
Because my lord, your lordship was pleased to like
1 minute. Hey, ask him, that's it. 15 also.
yes, my lord, I must come.
115.
115.
115.
At 2 p.m., my lord, there is division.
All right. Please, Mr. They please take it now. File it on that.
Yes, my lord.
Come at 115.
Yes,
110. So that.
my lord, I must want. I must come.
Yes.
Item number 3.
My lord, is that matter, my lord, where the cost has been imposed upon the plaintiff for non-appearance
Yes.
due to the medical condition, my lord.
Yes, sir.
Objection filed.
Yes. This is the objection filed by you before the trial judge. Yes.
Against the 151 application.
Yes. That was disposed of by the
Recalling application, that was also disposed of, and 1,000 rupees additional cost was imposed.
Yes. Where is the application under 151?
But I'm showing, my lord. Starts from, my lord, the page 22.
All right. Yes, sir. Yes. So you can use the microphone. Please use the microphone. Yes.
Since the trial court had gone into the matter, had it been a solitary case of just one adjournment on the grounds, not we will stand by my learned friends that. But it's a case between the clients, not between us. As Lordship Khan sees not more than 10 times they have taken adjournment since 22 to 2005. They have been taking adjournments previously on the ground of the advocate's illness. And thereafter, when this application came, and the
What is the stage of the suit?
but
7172 was allowed. my lord.
7.2 has been allowed.
After my order 39 rule 7 was pending and no prejudice to the defendants, my lord.
Now, but the trial court, while disposing of this application, passing this order, had referred to a judgment of the Supreme Court. I shall just play that thing, but
Yes.
three.
The judgment basically speaks about the absence of the advocates.
Sir, please allow him to submit. Yes. Yes.
But head note D, what is the trial court has also referred to this, page 2
Page 2 of the impugned order.
of the no, page 2 of the judgment.
Yes, page 2, yes.
Mali, page 2 of the judgment of course, in page 1 also they have referred to those, but what the trial court has referred to is under clause C on the side that however the absence of the lawyer or his non-ability because of professional work in other courts or elsewhere or on the ground of strike call or the change of the lawyer or the continuous illness of the lawyer, the party whom he represents must then make alternative arrangement well in advance, or similar grounds will not justify more than 3 adjournments to a party during the hearing of the suit. That is what Order 17 Rule 1 also speaks of. And 17.2 gives the power to the trial court for the cost to be
Yes.
imposed.
No, what is the stage of this suit?
Order 37 Rule 7, 39 Rule 7 is yet to be heard. And that is pending.
The suit has not reached the evidence stage.
But may I show only one document?
Sir, please allow him to make his submission. You will get your chance. Yes.
Sorry.
Please take your seat. Yes.
Since 2022, this application is pending. And if I'm not wrong, more than 10 adjournments have been taken on the ground of the lawyer's illness. Now the illness of the parents or the in-laws have come. So if you take this application solitary, well, I'm with my learned friend. But if we take up the past conduct of them, but I justify the order passed by the learned trial court, and there is nothing wrong in the order passed by the learned trial court, while passing this order of cost of only 5,000 rupees, not on fund, that comes under clause 17.2 of the CPC. 17.1 is the adjournment, and 17.2, Order 17.2 is the provision for cost for adjournment. This judgment, relying upon this judgment, the trial court has held this, and I do not think that there is any infirmity or illegality in the order passed by the trial court. In view of the judgment that she has herself referred to in the order passed by her. This judgment is referred to by her in the order, my lord. And on the basis of this order, or this judgment, my lord, she has passed this order of cost. And even then, when they not paid it, the court again asked them to pay another 1,000 rupees to DSS celebrant instead of that. So I support this judgment, my lord, this order of the trial court, my lord, and I say there is no infirmity or nothing wrong in the order which should be interfered at this stage. These are my submissions.
Yes, what
I
is
will kindly wants to take page 13,
30?
13,
Oh, 13.
13, yes.
Yes.
And when the 712 application was allowed, but thereafter in the middle portion ordered, at
Yes.
this, and the second para, at this stage, the petition under section order 39, rule 7, filed by the plaintiff is taken up for hearing, heard both sides in part, fixed this for further hearing. And thereafter, the suit was transferred, page 17.
Yes.
Transfer date, my lord, kindly see, 10th May, it was assigned to the second bench. It was kept pending. It was assigned on 10th May 2024 to the second bench. Second
Yes.
bench. 2024, 10th May 2024. It is written in the website. I have not given my document. It is website document. And then, my lord, can you see page 19?
Yes.
The previous day's order, the order improved and the previous day's order, 26 July. The PO was leave. I couldn't move on that day.
Yes.
Thereafter, this impugned order was happened, and on that fateful day, I was not present. Because of the circumstances I have showed in my 151 application, there was a kidney tumor operation going on of my father-in-law, and my wife's reports were also being secured of the gallbladder operation. Both operations took place in October. This happened in September. Both operations took place in October. In November, they were discharged. I have given all the papers.
No, on 25th of September, what happened?
I was not present. I have indicated someone to go and file an adjournment application. That was filed, but that was not considered.
Where is that application for adjournment? On 25th of September?
That copy is not with me.
Yes.
I indicated an advocate to appear and take time.
Item number 4.
CO disposed of. Yes, next.
Item number 4.
Allow.
4, Lordship.
4, yes.
Seeking for an
That's happened,
adjournment. I'm seeking for an adjournment as because
No
of the-
adjournment, sir.
Lordship, as because the mentioning notice has been served, but it has not been delivered yet. Last day this matter was taken up, your Lordship opined that we had to service the mention.
Start mentioning notice, not yet delivered.
Yesterday only we
You are for the opposite party. The advocate is there. Why are you serving to the party?
I didn't find the advocate, that's why. Anyways. Lordship, this is my application for extension of interim order, Lordship.
After hearing the learned not today. Next.
Item
This
number 5.
5, yes.
The extension of interim order up to 31st August বলে the interim order.
You have served.
Yes.
Evidence service filed in court today is
Number 7.
My lord, in item number 6, I am the advocate on record petitioner, but we haven't mentioned the matter.
you have not mentioned. You are for the
Advocate on record petitioner. তাহলে চলেই যা।
Item number 7.
you have yes, Mr. Kormakar, you are for the petitioner.
Item number 7 I am for the petition.
7.
It's so sad.
Take the la-
Item number 8.
Same.
Fight it in, fight it in, fight it in.
He has come.
After hearing the learned advocate
What had happened?
Yes. এই এটা বন্ধ করুন তো।
পাস করে যে খাওয়াই না সেটা তো
My lord, please to avoid that both will be hard together.
I'm keeping it after I'm extending it for a limited period. I'm keeping it after the vacation.
Let us retain its position because it is running in the list.
Under the heading application,
Under the
it
heading.
will appear
Let the retain its position so I can.
after hearing and this is what are these two applications?
Can number 6.
6 was for extension and 4 is for vacating.
4 is for
Six,
vacating.
extension trace of can 6.
Can 6? Oh,
Where is
No trace of
no.
can 6.
আমি 4 এ আছি।
I got a copy of can 6 bullet possible.
Probably it was filed
File has not come, I think, bullet before.
26th.
Please give a copy.
Giving my
6 টাকে allow করে দিন, লিখে দিন।
I appear on behalf of the defendant petitioner, madam.
Yes.
No, no,
Who is for the opposite party?
Saurajit to balance.
Uh,
I have served.
প্রথমটা petitioner non appears January 2025. Yes, next January 2026.
Item number
Yes,
12,
yes.
my lord.
You have filed, Mr. Mukherjee, you had filed a can application for extension.
Earlier it was there, madam.
Earlier it was there.
Yes, yes, that was disposed of, madam.
একটু দেখে নেবেন তো ক্যানটা ডিসপোজড অফ কিনা।
Subsequently, the order was
যদি
passed.
ক্যানটা ডিসপোজড অফ কিনা একটু দেখে নেবেন, নাহলে ডিসপোজ অফ
and
করে
it
দেবেন।
was extended till August.
In item number 10, ক্যানটা একটু দেখে নেবেন।
ঠিক
Yes,
আছে।
yes. What is the next matter?
My lord,
12.
item number 12, my lord, I am appearing for the
I
petitioner,
oppose
my
this
lord.
application.
After hearing the learned,
This is a preemption matter or
after hearing the matter, after hearing the learned advocates for the respective parties, the
Lastly, your lordship allow the interim order
I have allowed the interim order.
Extended.
After hearing the learned advocates for the respective parties, the interim order is extended till the end of the.
You know, 14, my lord, this is the FDO service, my lord. Your lordship was pleased to pass an interim order, my lord, on 27th of January.
You have served, none appearing. Every service filed in court today is taken on record. Mr. Ghosh, learned advocate, appearing for the petition submits that the opposite parties have been duly served. However, none appears to oppose the prayer for interim order. The interim order passed on
27th of January 2025. We have filed an application.
Why?
Application for extension, my lord, because it could not be heard out because the matter was pending.
The
And one.
an order and disposed of. Yes, next. You are from the opposite party.
Your Lordship, I'm being led by Mr. Ishan. I'm praying for a short passover, Your Lordship.
Till when the interim order is there?
Sir, Your Lordship, 31st,
After hearing the learned advocates for the
Item number 16.
Yes, yes. Yes, Mr. Sanal, you are appearing.
I am appearing, Lordship, one
Service.
earlier occasion. It was extended, Lordship. Malloy Krishna Day is appearing for the opposite
Interim order is still.
end of August, Lordship.
Learned
The petition.
Allowed by the court. That is their whole people. Now,
has to be. They will not agree to that.
No, my lord. They have hired all the provision of law.
recovery at stake.
There are several litigations pending.
Order number 33 once, my lord. That is their whole grievance, my lord. Court has imposed the cost, allowed our WS, man. That is their whole grievance, my lord.
No, my lord.
Court. Now, kindly consider, my
No, no, it will take the
the service action along with the willful defaulter proceeding before this, my lord, before the trial.
I will not challenge the service matter.
Order
The
number
landed trial has already stayed the auction.
their expertise, my lord.
Stayed the auction of the properties.
I am extending it. I am fixing it.
Recovery proceeding at stake, my lord. They have obtained 1 crore rupees loan. Kindly, my lord, consider the prayer of the suit. Not an ordinary case, my lord. Maybe a commercial dispute. I will take that point.
Soon after hearing the learned advocates for the respective yes. Who is appearing?
Already appeared one. Interim order, my lord.
You are appearing for the opposite party. After hearing the learned advocates for the respective parties, the
My lord,
interim order Because they are contested matters. If consider, if these contested matters are kept, I do not have any difficulty. I can keep all then motions will not be taken up. Don't mention for updates. I'm telling you.
Kindly consider motion
Any one of you mention for motions, I will take up contested applications. Tomorrow itself.
kindly consider why should have been stayed?
CDM case, CDM case, 90, item number 16, item number 16, my lord. Senior CDM case, my lord. For only did. 16 টা কি হচ্ছে? 16 টা কি হয়েছে? কি order হয়েছে?
My lord, services in effective.
Every service filed in court today is taken on record. Yes,
Yes, my lord.
Beg to appear, my lord. My lord, here is the service.
My lord, my application has not come. 2 days I am mentioning.
Mentioning, please mention tomorrow. If your application has not come. Yes.
My lord.
Call the next matter.
My lord, I beg to appear, my lord. Interim order, my lord, till end of August. Service effective.
Every service filed in court today is taken on record. None.
For the state responding.
For the petitioner, my lord, the initial interim order was passed on 7th of
After hearing the learned advocates for the
This is my video service, my lord.
yes.
My lord,
After hearing the learned
the submission on 21st May of 2025. Not correct, Doctor. As per their submission on 21st May 2025, Doctor, the submissions are not correct.
submission
Submission by the learned advocate was not correct.
was not correct.
Kindly come to page the
All right, file an application, appropriate application. After hearing the learned advocates for the respective parties.
Lordship, I am on behalf of the petitioner. This is affidavit of service.
Every service they have received. They have received.
Lordship.
Every service
Yes,
filed,
yes.
the
the retained statement was not accepted because 1 year have been passed, no retained statement has been filed. That is why the learned court below rejected.
You are for the petitioner.
My only prayer, my lord, the retained statement not because my lord, the suit is for 2G. Let it be allowed. They will file the retained statement before the court below, subject to payment of cost. I am not stand on the.
Subject
oppose. 1 year have been passed. 1 year no retained.
Subject to payment of cost.
Yes, 1 year have been passed. If my lord,
Very short matter, my lord.
we very short matter, my lord.
Preferred an application under order 7, rule 11. At that point of time, written statement was not filed.
Cost, pay some
Yes,
cost.
I am ready.
That was not filed, my lord.
Pay some
Intend to
cost.
file after my
Pay
application
some cost.
Yes, I am ready.
Yes. How much cost?
My lord,
50,000.
my lord, I am appearing. Kindly visualize.
50,000.
But kindly visualize. I am appearing, my lord.
No.
50,000.
Yes, how much?
Nominal cost, my lord, I will contest.
Uh,
And immediately on the next date, my learned friend will file. My learned
yes, what is the next date?
10th September, my lord, 10th September.
10th September. Yes, you file within 10th September.
My written statement is ready. I was not allowed to file it.
You did not file because the order 7 rule 11.
Order 7 rule 11 was
This application under article The learned trial judge is request.
I'm opposing this application.
My petitional application, the interim order was passed on 12th of June 2025.
The revision petition.
May I just indicate first, my lord, it is, my lord, to be extended because, my lord, it is till August, my lord, 31st. It is under the heading of extension of interim order. This relates to that matter. my
After
lord.
hearing the learned advocate. Yes. 26, yes.
Till 31st of August. I was only not beseeching if it commenced to fix the matter, particular.
You are appealing for the
Your lordship, my lord,
directing the miscellaneous appeal to be disposed of.
on the last occasion, your lordship, my lord, directed the municipality, my lord, to bring report, my lord, in the form, my lord, whether any sanction plan is there, and my lord, the what other things, my lord.
The tribunal order, there is that particular unauthorized construction, there is no sanction plan.
There is no sanction plan.
Regarding the old building, thereafter, my lord, after 4 stories.
I am directing the appeal to be disposed of.
Only one thing, my lord, your lordship has passed an order, my lord, in another divisional application, my lord. I have just, my lord, sought, my lord, to bring the copy. Now, whether stay is, my lord, a matter of.
Alright, then I am extending it, I will hear you.
My lord, no, my lord, kindly considers, my lord, this aspect, my lord.
Kindly extend the interim order.
Then I can extend. If I have to hear this, I am extending it, I will hear. Or I can direct that this appeal to be disposed of within a certain time.
My lord, in that case, my lord, kindly, my lord, direct the tribunal, my
The
lord.
next date is fixed.
My lord, 16th of December is the next date fixed, my lord. My lord, the appeal is otherwise ready for hearing. My lord, on that day, my lord,
Your lordship is keeping me protected. So that
I will protect you till the disposal of the miscellaneous appeal.
Very
Or the municipal appeal, how it is.
BTA appeal.
BTA appeal. This application. Call the next matter. Yes.
I appeal for the petitioner, my lord. This is not against an order passed by the my lord Chief Judge City Civil Court in my lord proceeding under my lord Murshidabad Estates Act. There is a provision, my lord, those eviction proceedings. There is a provision for appeal before the landed civil principal civil court.
Who are you?
I am my lord the Murshidabad Estate, State of West Bengal to the Murshidabad Estate.
Yes.
Now, my lord, proceeding.
What is the order impugned?
Order impugned is not an order by which the order of eviction has been set aside. The court went on to proceed to my lord, assume the role of a writ court by directing consideration of representation, acceptance of rent, all beyond my lord, scope of appeal. Order of eviction was under challenge. Court could have at the most set aside the order. After setting aside, court proceeds to direct that you accept the rent, you consider the representation. It should have been considered. Entire rent.
Where is that?
That part is not at the end of the order.
The last paragraph.
Page 11 onwards.
Permitted to deposit the area rent.
And Lord, page 11, last paragraph. This is not beyond the scope of the appeal. And the
eviction order was under challenge.
Eviction order was under challenge.
There is substance in the argument of Mr. Banerjee, learned advocate for.
Matter returnable, my lord.
Yes, I've said contested application after 12 weeks. Yes, next.
Item number 28.
I am for the petitioner, my lord.
Yes.
Ex vitae trial, my lord. My lord, order number, my lord, see the order number 22.
Of the partition suit.
Partition suit, my lord.
What is the stage?
My lord, substitute application filed, my lord.
Has been filed.
Yes, my lord.
So you have been directed to take steps. You have
My
to take steps.
My lord, expedite style file an application. Order number 22, reject the application, my lord.
This application.
My lord, Mr. Shobhan Mukherjee is appearing for the opposite parties. Due to his unwell, due to he could not come to court. Kindly make it not today.
Yes, Mr. Ghosh, what is this matter about?
My lord, in a suit for eviction, my lord, the opposite party plaintiffs have their separate respective 3 residences. My lord, evidence have already been closed. Defendants completed their argument, and the plaintiff was about to complete their argument. In the meantime, on application 1817 for recalling of the PW, that should not be allowed by the learned court below. Well, considering the judgment of this recent judgment of the Supreme Court, it should not be exercised lightly. It should be exercised very.
But they are paying for time.
Appearing on behalf of the defendant challenging for the order of appointment of commissioner, my lord.
Yes.
My lord, the order for appointment of commissioner is not proper in law, my lord. Before
What is the
framing
suit for?
my lord,
What is the suit for?
what is suit for recovery of khas possession, declaration, and permanent and mandatory injunction, my lord. My lord, before framing of issue or recording of evidence, my lord, the learned court has appointed the commissioner. Actually, this appointment of commissioner, my lord, before framing of issue is premature. So at this stage, it amount to collecting of evidence, my lord. Evidence for plaintiff, my lord.
What is the suit for?
This is suit for declaration, recovery of khas.
You are the defendant.
Yes, my lord, I am for the defendant.
Yes.
And the plaintiff has filed the petition for appointment of commissioner, and it has been allowed by the learned trial court. And the main allegation of the plaintiff is that the defendant is encroaching their land and constructing building thereof. But it is the plaintiff who must prove their case, and the burden of proof cannot be transferred to the commissioner, my lord. And my lord, kindly travel to the page number 38, my lord. This is the application which has been filed by the plaintiff, my lord. My lord, there is a point for local inspection, my lord. Point number A. My lord, may I read? Page number 38, my lord.
Yes.
My lord, there is a point for local inspection In point number A, they have seeking that, is there any side space between the southern side of the fruit property and the construction of the dependent? If so, details. My lord, direction to check whether the defendant has left any side space or not. Nowhere can it be found in the plain, my lord. Nowhere it can be found. This claim has not made in the plain, my lord. So asking for commissioner to check whether there is a side space or not, it is, my lord, beyond the scope of the suit, my lord. And my lord, if we see the page number, point number 2 also, B, whether any kind of construction was made encroaching the suit property. This is, my lord, purely collecting of evidence, my lord. My lord, a commissioner may be appointed to clarify matter which cannot be proved normal or due normal course of evidence, my lord. So the question of whether the defendant has encroached or not, it can be proved by crossing the evidence, my lord, or
Can be proved, encroachment.
My lord, it can be, my lord.
Can be proved. Thank you.
There is a
This application under Article 227.
2025, the title suit is 24.
24.
24.
Title suit number 24. 245 of 2024.
245 or 2020.
Item number 32.
So great.
Yes.
I'm for the petition. This is application for expeditious disposal of a title suit filed in the year 2018, my lord.
What is the stage of the suit?
The issue has not been framed since 2023.
This application under Article 220.
Secretary, my lord, petitioner, my lord, I'm the decree holder
Yes.
in the suit, my lord, and the respondent in the appeal. Now, my lord, in the 2000
Occupation charges.
my lord, one line order, my lord, of stay, entire proceeding and entire execution.
No occupation charges.
No condition. And my lord, that is in 2018 appeal, stayed in 2025.
Appeal is ready.
Appeal is, my lord, otherwise ready.
Mr. Banerjee, I can direct the appeal to be
My
disposed.
lord, my lord, I specifically asked that. My lord, my instruction is, my lord, that they will, my lord, anyway take some time, my lord, to move the appeal, the respondents, my lord. There are number of respondents, my lord. So, my lord, I was instructed, my lord, to press, my lord, for the condition to some conditions to be set for my lord staying of the order.
Mr. Banerjee, learned advocate appealing for the petitioner submit. Yes, call the next matter.
34.
My lord, my case is slight different with this case. Occupational charge awarded, but as per rules and demands of the appellant tenant.
Appellant.
Yes, appellant tenant. I am the decree holder, my lord. My lord, kindly come straight away, my lord. Annexure C, page 20. What is I object?
I am directing the appeal to be disposed of.
My lord,
Otherwise, here it will be kept
my
pending.
lord, kindly.
I appreciate that. Otherwise, it will be kept pending.
My lord,
They will take advantage of this.
My lord,
What is the occupation charges fixed?
only 15,000 registration as per evidence of the register, my lord, it will come 1,05,000 per month. I enclosed that. I relied on page 26.
The petitioner who is 35 yes.
My lord,
Yes, yes.
my lord. The opposite party filed a misappeal against their rejection of their Order 39 Rule 1-2, my lord.
Expeditious hearing of the miscellaneous appeal.
Yes, my lord.
What is the stage?
The SRAD, my lord, is not completed yet, and LCR is also not received, my lord.
Service return is not complete. How can it be?
Since 2020, my lord, it's pending.
Service return, if it is not complete, cannot be done. This application under Article 227 of the Constitution.
Twenty 2023. Let the misappeal be lordship expedited.
Respondent files a petition paying for expediting. Thereafter death took place.
No,
Maybe your predecessor appeared. You have not appeared.
we have lordship entered appearance lordship. Kindly.
Thereafter it is SRD.
May I come back tomorrow lordship with instruction lordship.
No tomorrow, business.
Now kindly expedite lordship the misappeal because lordship it is pending since 2020
This
lordship.
application under
within appearance within 2 weeks.
You have appeared?
হ্যাঁ,
আচ্ছা তাহলে ওই যেখানে বলেছি না assures this court that
Diff.
Yes.
Lord, this is an interesting fact. In a small causes court, the tenant's counterclaim for recovery of possession has been allowed.
Tenants counterclaim for recovery.
Lord, peculiar circumstances. And even that too without
Has been allowed.
allowed.
How a revision is maintainable?
Lord, for Lord, amendment, Lord, order 6 rules.
Yes, so you are saying
No, Lord,
counterclaim allowed.
and absolutely an unreasoned order.
Show me the plaintiff. You are the plaintiff.
I am the plaintiff.
Show me your plaintiff.
Lord, plaintiff is at page number
17.
17. Lord, prior to filing of this counterclaim, Lord, on the same self causes of action, they have instituted one
So you have filed a suit for recovery of khas
for your
position.
position on the ground of defaulter reasonable requirement. And my lord, I have also stated that the suit property is under lock and key for last about 26 years. My lord, he comes and file an title suit, my lord, in the city civil court and prayed for a decree for declaration that he is a tenant along with a mandatory injunction directing for removal of that lock. My lord, that suit was dismissed for default under Order 9 Rule 8.
Where is the written statement?
Written statement, page 29. The relevant portion is page 30, 31. 31 is the important.
Oh, yes. So their case is of forceful dispossession.
Forceful disposition.
So that is why.
Let the small, they have earlier filed on title suit in the city civil court on the same causes of action. That suit was dismissed for default. The part under Order 9 Rule 9 comes into play.
Dismissed for default at what stage?
Kindly comes to the dismissal order, page 62 and page 73.
Page 73.
No fresh suits can be filed under order without restoration under Order 9 Rule 9. Second of all, I have also annexed the plaint. Same causes of action. Page 49 is the schedule of amendment.
Show me the application for amendment.
Not the page 49. And it starts from page 46. The schedule of amendment is at page 49.
And where is the
earlier suit plaint? That is at page number 68. Not 62 is starting and 68 is the causes of action. Kindly considers the section 19D of the Small Causes Court Act. That Small Causes Court has no jurisdiction to decide the aforesaid issue.
It prima facie appears to this court that Yes, next.
Item number 37.
I am for the petitioner, my lord. I am
Yes.
paying for expeditious hearing of title execution case number 9 of 2017, my lord. Pending before the land.
Who are you?
Lord, I am the plaintiff. I have got.
Degree holder.
Yes, my lord. Decree holder, my lord.
Any miscase pending? What is the miscase
I
for?
have
Miscase
filed
44
on miscase being number 44 of 2024 for police assistance.
Who has filed that application?
I have filed. My lord, kindly see the order dated, my lord, 17th May 2025, my lord. My lord, against the judgment and decree, my lord, they preferred title appeal, they lost. Thereafter, second appeal also lost. Despite that, the learned court below, my lord, allowed the opposite parties to file written objection against the miscase number 44 of 2024 for police assistance.
This application under (38) yes.
Lordship, item 38, I am appearing for the petitioner. There is just
No.
two.
I am appearing for the opposite parties. Today we are appearing by Vokalatnama. We are appearing today by filing Vokalatnama.
Yes.
I am for the
Yes, yes.
parties.
Well, just, I am the defendant petitioner. Well, it is a tenant under the opposite party plaintiff, my lord. 2 days delay, my lord, in depositing the
We
rent
received no copy.
under
Will
7.3.
direction be given for servicing the.
2 days, please wait, sir. Well, 2 days delay in depositing the rent under, immediately, my lord, 7.3, and immediately, my lord, 7.3 application filed. Well, it is not the fault of the defendant, my lord. What happens, your lordship knows, my lord, the learned junior advocate, my lord, tried to deposit 2 days, my lord, 14th and 15th of the month was a holiday. 16th and 17th, my lord, they tried but could not. Immediately on 18th, put up petition was filed. But kindly consider this.
72 was filed, no?
Yes, 75
Yes.
filed
72
allowed.
disposed of.
Yes, I was depositing rent.
You are depositing rent.
Only in one
So it's a subsequent default.
my lord, this is not a my lord, it is, yes. I bow down.
Yeah, default. What are you saying?
I bow down. I bow.
Subsequent default.
My
How
lord,
can it be condoned?
my lord, 2 days.
I am bound by my own judgment.
My lord, kindly visualize lawyer's
I'm
fault.
bound by my own judgment.
Lawyer's fault, my lord. I have taken that.
Sue the lawyer.
My lord, junior lawyer, my lord, kindly, my lord.
Sir, cannot be held. The court does not have power.
My lord, moreover, the order is also an infirmity. My lord, kindly come to the order once.
Yes, yes. Show me the infirmity, I will consider that.
But my lord, kindly see, my lord, the order date, my lord, certified copy.
Yes.
Today is fixed for further hearing of petitions dated 18/12/2024.
Which portion you have?
The order dated 13, well, certified copy. Well, certified
Yes,
copy, it is
yes.
the 5th page, I think.
Page 5.
Page 5th page of the certified copy.
Yes, 5th page of the
Certified copy.
Order dated 5th of March.
16th May, 16th.
Or 16th of May.
Kindly see the informative. My lord.
The ordering part? No.
No, my lord, kindly see the top. My lord, today is fixed for further hearing of petitions dated 18/12/2024 and hearing of the petition under section 7(3) of the WBPT Act dated 31/1/2025. And then, my lord, kindly come to my submissions, my lord. At the bottom.
What is the infirmity? Please tell me.
It was a 2025. Now, my lord, kindly see the ordering portion at the last.
Yes.
My lord, kindly see the ordered the petition under 7(3) of the WBPT Act filed by the plaintiff on 22/8/2022 is allowed on contest. My lord, petition dated 2025 was before the court and 2022 is allowed.
22nd of August 2025 was before the court. That's a very good ground. Anything more?
Kindly consider, my lord. Junior advert, that plea also been taken. My lord, 3 days, my lord. It was Saturday and Sunday was a holiday. 14th and 15th on that particular month was a holiday. My lord. Your lordship can.
No. I cannot. I am bound. Supreme Court judgment, also by my own judgment.
Well, at least this.
I'm telling you, there was no default in that case. Only a marginal shortfall of 10 or 15 rupees of the rent that was being deposited. There was no default, I am telling. Not for a single month. But only 15 rupees less was being deposited.
Scope.
This order may be quashed and remanded it back. Order may be quashed because, well, kindly see at the top, it is 2025 petition and court is allowing 2022 petition.
Typographical error.
There is no necessity to file 7(3) also. It's automatic. Non-compliance automatic. Even if I dispense with this application, even then, even if I accept your submission, I set aside this, that no, there was no application of 2022, automatic, it takes in when there is a failure. There's
But
no.
not on the client cannot, though I leave it on your lordship. But it is not on the fault of the.
This application under Article Thereafter, some ray of hope was there. That has ended on 13th of August 2025. Because there was something in Devashish Pal for that another matter, 13th of August, that judgment has come.
But here, my lord, it was not the client's fault. Here, the fault of the advocate to deposit. That was the reason.
Court to extend, that's the difficulty. Court do not have the power. That decision I have considered 151, 148, everything.
Yes.
You have seen that decision.
Yes.
I have
But
considered that.
Section 40.
Section 40 also.
Section 40 I have considered with regard to that, but I have considered 151, 148, all those points were argued.
Mandatory provision.
And in one of the matters, I think it was also argued that those decisions are pari incurium. These Vijay Kumar Singh, Devashish Pal, that argument was also made. I had the occasion to consider that also. And that decision has been approved in the Supreme Court, not interfered with. Yes, call 39.
39.
Item number 39, Lordship, learned advocate appearing for the petition has gone to hospital, Lordship, for heart checkup. His clerk has requested me to pay for a passover. He's on his way, Lordship. My instruction, Lordship. His clerk is requesting to pay for a short passover. He's coming.
Passover?
Lordship.
Passover next.
Item number 41.
My lord, I am for the petition.
Yes.
For the caveat report.
Okay.
Yes.
I have served them, my lord. It's a suit for declaration and permanent injunction. Both the courts below rejected my prayer for ad interim injunction.
Ad interim injunction refused?
Refused, my lord.
By both the courts below?
By both the courts below. My lord, fact is that
miscellaneous appeal, ad interim refusal or miscellaneous appeal disposed of?
Miscellaneous appeal disposed of.
Then I am directing the injunction application to be heard of.
My lord, in the meantime, facts of the case.
Both the courts have refused. I am
My lord,
directing
in my submission, wrongly refused, my lord. My lord, it's a declaration.
The ad interim refusal by the trial court was on 2023. So you are without any interim order from 2023. So no ad interim order can be passed. Unnecessarily, this will be kept pending. I am directing the injunction application. It's otherwise ready for hearing. Have you filed written objection?
Perhaps not, my lord, because I have filed the written objection in the appeal.
The appeal.
So you file how soon? What is the next date fixed?
After refusal of by the misappellate court, I have to take instruction.
All right.
Misappellate court has directed
objection within a fortnight. This application under Article 227 of the
It's a suit for declaration.
Show me your plaint.
Plaint, my lord. Plaint is at page 8, my lord.
Yes.
Plaintiff and defendant number 3 are the co-sharers of the suit property. A schedule suit property. Defendant number three from a undivided property, a schedule property, gifted a demarcated portion to his wife and minor son.
Please give me a minute. Where is the ad interim order of injunction passed by the appellate court?
That was not annexed, my lord.
You have not annexed that. The order which is in your favor, the only order you have not annexed.
My lord can find it from the order sheet, my lord.
Which order sheet?
Miss Appellate Court order sheet, my lord. Page
By
4.
that it has been vacated, sir.
My fault, my lord. It is my fault, my lord.
Yes. What is this suit for?
For declaration and permanent injunction, my lord,
Yes.
my specific prayer is the declaration that by the gift deed impugned, the defendant number 1 and 2
How have you become the owner of the property?
from inheritance.
Show me from your plaint.
Paragraph.
So what is the relation between the plaintiff and the defendant numbers 1 and 2?
1 and 2 are the wife and daughter.
They are your co-sharers?
No, until the defendant number 3 is alive, they are not co-sharers. After the deed of gift,
No,
they are
defendant number 3
is my brother.
is your brother.
And 1 and
Plaintiff and the defendant number 3 are the sons of Jugal Kishore De. Jugal Kishore was the original owner. Now this Indrajit De, defendant number 3, he executed a deed of gift in favor of 1 and 2. Defendant numbers 1 and 2. Yes. So now the defendant numbers 1 and 2,
they have become co-sharer.
they have become your co-sharers.
But my grievance is that defendant number 3 could not gifted the demarcated portion of a undivided property, my lord. This is my only declaration in this suit. And in the meantime, not to transfer to any third party. That is my prayer for injunction. Only to that.
So if he could not have,
Learned appellate court.
if he could not have gifted this, then the relation is that of co-sharer.
No, sir.
Co-sharer. So without paying for partition, is this suit maintainable?
My lord, learned appellate court holds that, but if I have a declaration, I have prayed for any
Suit is
declaration.
not maintainable. If you are entitled to further reliefs, not paid for that.
My only relief is that for declaration that.
And you have also not paid for declaration of your title in respect of this. You have only said defendant numbers 1 and 2 do not have any title by much of. But what
Absolutely, no, not I have not disputed their title, but only.
No, that is your prayer.
That not absolute ownership. I have made that not accurate absolute ownership of the suit property.
So according to them, they have undivided interest in the
undivided
property.
interest.
Along
I have
with
not
you,
disputed.
you have not paid for that. If there is any dispute with regard to joint possession and other things, you have to file a suit for partition.
No joint possession has been disturbed, my lord. But
what they are trying to do,
they are trying to transfer the said gifted portion of the undivided property to a third person. And learned appellate court rightly holds that. Kindly turn to appellate court order, my lord.
Yes.
At page 4, the issue whether a co-sharer can execute a deed of gift with specified demarcation in spite of the entire property not.
But what is the suppression by the appellate court?
Suppression is that some other co-sharers have gifted their share to me through the plaintiff.
Demarcated portion.
Not demarcated. I have.
Show me the deed.
Deed I don't have, but I have filed the rejoinder to their objection in their.
Show me the deed, sir, that you have also not got demarcated portion. Show me that.
That I don't have at present.
I'm directing the trial court to decide this. This application under Article 227 of the Constitution of India aforesaid observations and directions. Next.
Item number 42.
But I am for the petitioner. My lord, first time this matter is come before your lordship. This is regarding, my lord, the expeditious hearing of a title suit, my lord, which is pending from 2015.
What is the title suit for?
My lord, for eviction, kindly come to page number 11, my lord, my plaint, my lord. For eviction. Suit for eviction and recovery of khas possession.
What is the stage of the suit?
My lord, hearing, my lord, the issue is already.
It have been framed.
Yes, my lord.
It is at the peremptory hearing stage.
Framed, yes.
This application under Article 2.
Pray one thing, my lord, inadvertently, my lord, in my prayer, I have mentioned 2016 in my 800. Maybe, my lord, correct.
On the prayer, ekdom upor diye on the prayer of yes.
This is the prayer for early disposal of the suit, suit for declaration and permanent injunction. Petitioner before lordship the plaintiff.
What is the stage of the suit?
Stage, my lord, the date is fixed, my lord, the November.
For what?
Evidence. For evidence.
For evidence of?
Evidence of plaintiff.
For evidence of the plaintiff.
Two already framed.
This application under Article 227 of the Constitution. আগেরটাই লিভটা কেটে দিন, কারেকশন করা আছে। আগের যেটা বললাম না যে প্রেয়ার পোর্শনে
Disposal of the title execution case number 4 of 2023, my lord. Degree, I have got the degree on 2014, appeal dismissed. Against that, my lord, finally come to last 2 pages.
title execution.
Title execution.
How many miscellaneous cases are pending?
My lord,
In the execution case.
That is why, my lord, last 2 pages of the 35
That is why I am asking you, how many
Yes, yes, yes.
miscellaneous cases pending?
My lord,
The miscellaneous case of 202 of 2024.
yes, yes.
What is that?
My lord, thereafter,
Under
my
what
lord,
provision?
thereafter, my lord, for section 47 in the order.
47
Yes.
pending.
My lord, my instruction, it has been disposed of, but
When?
from the order sheet, I have not seen, my lord. That's why, my lord,
When?
I have not seen, my lord, from the order sheet, my lord.
Miscellaneous case 47 is the first 47.
Yes.
So there are many 47.
No,
applications to
that,
follow.
my lord, thereafter, last page, my lord, kindly see.
I am at the last page.
Yes, my lord, kindly see, next date was March 27. Thereafter, no date was given. My lord, that's why, my lord, I am requesting your lordship, my lord, kindly direct the trial court, my lord, to.
This application under Article 227 of the Constitution.
Forty-five.
45 is my application.
Yes.
But this is but my appeal from a refusal of an ad interim order of injunction has been held to be not maintainable. But
ad interim order of injunction.
Yes, refusal of an ad interim order of injunction.
Appeal not maintainable.
That is what has been held. Kindly see the impugned order, page 283. But the appellate, lower appellate.
Why have you not filed the certified copy?
Certified copy. There is some issue in the Alipur court where we could not obtain.
What is the issue in the Alipur court?
That's what I am told by some. I do not know.
The issue is that initially when an application was made for urgent copy of the certified copy of the order, they used to give the urgent certified copy of the order as soon as they were applied. But now what has happened, everybody used to give that application and some people were giving in the normal course of procedure, and that has been kept pending. There was a dispute with regard to the department and the learned advocates practicing in Alipur court, your lordship. And now what are they are doing? Now they are giving the regular certified copy of the order, and since it is pending for such a long period, so it will take some time, your lordship. That's why we have not been able to obtain the certified copy, your lordship.
Page 286, if lordship comes, that's where the ordering portion starts.
Yes. Where is the decision?
But I've not brought it, but I thought, well, I'll bring it. I'll bring it when in the second time. Lordship keeps it at 2 p.m. I'll bring the decision.
Issuance of notice.
Yes.
Refusing, that amounts to refusing to pass an
Yes,
administrative
well, it's a
order.
deemed refusal. But that is the sum and substance of it. And when the impugned order before the lower appellate court, it was recorded that I had prayed for ad interim order of injunction. But since the respondent already appeared, the lower court thought it fit to hear them out before passing an order of injunction. Collusive
Where
decree
is the order passed by the learned
My
trial
lord,
judge?
Lordship will kindly come at page 41.
Only 41?
41. And towards the middle of the page, Lordship will see heard both sides, on top of heard both sides, learned advocate of the petition raised objection to the same, prayed for the court to pass an ad interim order of injunction. Thereafter, I feel it prudent to give an opportunity to the opposite parties to be heard.
So there was a caveat.
There was no caveat, but they appeared.
They appeared.
They appeared on that day when I moved the application. They appeared. Appeared, made submissions on merits, and then said that they want another date of hearing.
There is substance in the argument of the learned advocate for
State fixed on 4th November, the learned court, my lord, I can make a prayer for ad interim. Learned court will consider passing or considering passing any ad interim order. But they will kindly consider that. Otherwise, my lord, they will not file a written objection.
Yes, call the next matter.
Item number 46.
I take
46, my lord.
46.
46, I appear on behalf of the petitioner, my lord. Lord, I appear on behalf of the defendant in a matrimonial suit and a petitioner in respect of an application under section 36 of the Special Marriage Act for alimony.
You are the wife.
I am the wife.
Yes.
Will I kindly see, my lord,
You want more alimony?
10,000 rupees given, I will only show two annexures. But I kindly come.
What is your husband doing?
But he is into business. We have claimed that he is earning 8 lakhs of rupees per month. But kindly come to page 78 onwards. Kindly come to page 78 onwards. We could hold off a bank account of January 2021. But kindly come 78. The in respect
Your
of
household expenses is 40,000.
My lord, I am.
Your medical expenses is 30,000.
My lord, I am not onto that. That I admit, my lord, what is written, I cannot improve that. I admit to that, but not 10,000.
How are you maintaining those expenses? What is your source?
I am not. There is no source, my lord.
So how are you maintaining? How are you incurring these expenses?
My lord, I said at the threshold, I said, my lord, what has been written, I cannot improve it here. But I will only say in respect of the 8 lakh alimony, 8 lakh income which I have claimed. Kindly come to page 7. They have not submitted any affidavit of assets. They are not appearing also.
Page
78. This is the bank account statement of the husband.
They are not appearing.
No, they are not appearing.
Your suit.
No, their suit.
Then the suit will be dismissed. What I'm saying.
Man, I'm in respect to the alimony application. They have not paid for the last 3 years.
That is a different thing. You are saying they are not appearing.
In the alimony also, in the miscase also, they are not appearing. Kindly come to page 78. This is the monthly January statement of 2021. The starting is 7,11,199. And Manu, kindly come to page 82.
I appear for the
5-10 minutes.
Yes. The husband of the petitioner number 1 died in the year 2019. The mother-in-law, my mother-in-law, that is the mother of the deceased, filed an application for succession certificate claiming 1/3 share of LIC policies amounting to rupees 5,30,000. That proceeding was contested, allowed, and succession certificate was granted in my favor. I was the opposite party number 1 in the said case. Subsequently, my lord, since the operative portion of the order says that a subsequent court fees is required to be paid by the petitioner, but I filed an application permitting me, being the opposite party number 1 heading, to pay the fees. But that petition was rejected. Although in the petition, my lord, no provision has been mentioned, but indeed this is a petition under section for amendment of ordering portion, my lord, permitting the
Where is your application?
My application is at page 30.
30.
30.
So this is only a put-up petition.
Put up petition as well as the my lord, permission to, my lord, put the
Sir,
requisite.
hearing matter over submitting when it has been fixed.
But it has been rejected. Rejected.
23rd of May.
My lord, the last order in, my lord, order number 50 dated 7th of August. I am challenging that order only.
7th of August,
7th
yes.
of August.
By
Can it be, my lord, preponed, my lord, because, my lord,
I
since
said it at motion.
motion. On record.
Considering that, I have fixed it under motion.
My lord, grateful.
Yes. Yes, Mr. Pan, why are you not present when the matter was taken up?
My lord, I was miscommunicated. I was under the impression item number 4. Now,
Who gave this miscommunication? Who was responsible? Yes, now you have seen.
yes. Now, my lord, kindly see. Kindly see. No, my lord.
Now also,
the affidavit has been, my lord, filed by the deponent. Kindly have a look at the paragraph 4. Kindly have a look at the paragraph 4.
the supplementary.
Paragraph 4, page 3. Paragraph 4, page 3. Now this is
4 months.
Yes.
Comply with
No,
me.
no, no. Can you see? This is being affirmed. Information derived from the record. Now kindly turn to the next page. Record what is been annexed. Kindly turn the last paragraph. Again the same story.
By the end of December, yes, within 4, that is by the end of December, to comply with the order.
After having the requisite fund from the recording body.
Mr. De, that is the difficult thing.
Again the
That
same
is the
thing.
difficult thing. You have made it a conditional one. This report is a conditional one. Page, the first page, annexure, R4. You have said after having the requisite funds. That's your headache.
No, my lord, I have stated that.
In the affidavit, in the annexure, if you say that you are dispensing with this, all right.
Yes, my lord.
You are not relying upon this annexure.
No, my lord.
So I only go by paragraph.
Paragraph 4.
Paragraph 4. Yes, Mr. Pan.
Yes, that is
My lord, can there be a condition, my lord? If they don't do this, then order will be revived.
Where is the earlier order? In the earlier matter, I have.
কি বলবো তো earlier order টা আনিস নি কেন যেটা আগে যেটা dispose of
Have to again pass another order. Otherwise, Ashun. Where is the modification application?
Modification application.
Can 1?
Yes, my lord. Can 1.
Mr. Day, I am recording your submission that
Yes,
you
my
are
lord.
only
Yes.
pressing
Yes, my
paragraph 4 and you are not
Yes, my
relying
lord.
upon that.
You know, 381, you will also desire that if the 330, then the matter will be taken up at, but the other side is here.
Item number?
381, when that's 415. 415.
It has been fixed.
415.
15.
Yes, today, my lord, this is 30. You will also desire that if this is 330, then you mention other side is here. My lord, I have informed the other side, my lord.
Item number?
At 315, you will also guys. 381.
381. What is the grave urgency, Mr.
No, urgency, my lord, the matter will be disposed of, my lord, only limitation ground. National Consumer Forum, my lord, dispose of my application and there. View section 5 you'll also view that section 5 will be considered and allowed, my lord. My other side is here, my lord.
Can you come back at 3:15?
And come back. I can come back. Actually, some 6 matters fixed at 3 p.m. today, so I was just wondering whether it will be possible.
That is fixed at 3 p.m. Because some motions are there. That's the only difficulty.
350, my lord, it will not make more time.
কখন নেবেন বলেছেন? Let me see how far I can proceed with the motions because motions.
At 350, my lord, we will be here.
Let me see.
Both are.
My lord, item 49, my lord, the next item 48, my lord, the next possible item.
So Datta, only difficulty is the motions. I do not have any difficulty in taking up fixed
My lord,
matters.
it is under, it was under, it was under motion, my lord. And
Motions, but you have got a chance. There are many single chance. Mr. Datta, both of you have got one chance.
Well, at 2 p.m. or about tomorrow for orders, my
Let
lord.
me see, come at 3:15. Let me see what's the position.
My lord,
No, please
item
come at
48, my lord. Item 48, my lord, if my lord,
What?
I am very, very disappointed.
Why?
New advocate has joined the profession, Milord. And Milord, there is no
Yes, yes.
corresponding obligation purport.
Yes, yes, yes.
Ki, Guru bolo, hai?
Yes.
Very urgent motion, leave is required.
What were you doing in the morning, Mr. Rai?
Yes, just now we are prepared today. In the morning came, it is prepared, 25th order passed for delivery position with police cell by first.
You have suffered a degree.
No. I filed an application order 97/99 allowed by directive. This is the special portion, etc., which no DD can be executed. Executing court without considering the same pass a degree in the entire property.
Okay, Order 21, Rule 19. So it's an appeal.
No, that is allowed by directing, by holding. This is the portion of the occupation which is under the petitioner cannot be executed pursuant to the degree passed. But the executing court, while passing the writ of issue of position, directed entered degree to be executed by 9th. 9th is the date. I know, but it to be mentioned, my lord. Why, my lord, it is required to be released from your lordship list.
Oh.
So, that is the only prayer I can make. Otherwise, I cannot.
You are filing without the certified
With
copy.
the certified, but the server copy. With the server copy.
To file with the server copy without the certified copy. Kore diye ar.
I am supplying the number. So to you mentioned or because I will not get it aside. Tomorrow is the last date.
কালকে আসবে?
That we can do this. The
only difficulty is that because some time is necessary for getting it scanned. That's the problem because I have called those persons from that file. That's the difficulty. Now, that is the procedure. Otherwise,
yes.
so some time is to be given, Mr. Rai, you know, because there's a heavy rush now. Heavy rush, so sometime if it comes, it will be listed. Once it comes, it will be listed. But saying that do it within in the this side prior to rising, it's maybe difficult because sometime because
let me appear tomorrow, but that date may be given so I can.
What is the date of delivery of poison?
1st September, Monday. That is why because in any event I cannot move before your lordship.
Mr. Bhattacharya is there, well, at fixed at 4 p.m. today.
It is legally possible.
There is a resolution at 3:30. Well, if lordship takes up, well, I don't have any problem because I am suffering the interim order. That is why I am.
Yes, difficult.
Well, I will defy the resolution he wants.
I don't.
He is saying, I am not saying anything. Don't put words into the mouth of
If
the
he is
court.
not agreeing, well, then well, that date should be fixed. Well, he is supposed to finish by 15 minutes. Well, I am suffering. Any day convenient to Lord.
Can be fixed, on any day next week. Tomorrow also there is a possibility.
Tomorrow?
It's like on a Friday usually we have a.
No, but I was told that since tomorrow there is
Yes, there is a program,
function,
that is why it will
something
not.
going to happen from 4:45. That is why that was impression given yesterday. That 3:30 will be.
Tomorrow we are subject to Mr. Dasgupta.
I think Mr. Banerjee will be a.
That makes it illegal. Please understand.
Tomorrow book launch would be there. So, my lord, there is a book launch.
Yes, that is why I was told that there will be no 3:30 tomorrow.
There is every possibility of a 3:30.
Every possibility?
Yes, because my lord, everybody will get free and then join the program.
I was told
They
that
have
for
to-
that
they
there will
have
be
to
no
get-
3:30
They
tomorrow.
have to get dressed up, my lord.
So
Let me clear program mystery.
let it appear because
On Monday, Tuesday, subject.
Any day convenient.
And to they are saying they did not find it
Russian
I
side.
argue this stupid point. Don't worry. But
I
on
have
this point,
completed submission. He is just supposed to answer on the judgment. That's it. Well, 15 minutes.
It will appear
Any day.
I do not know.
instead of Tuesday, Millet, can it be on Wednesday, Millet? That's suggested by Mr.
Let me see, check up because I think matters are fixed on. That's the difficulty. After 5 p.m. it is fixed.
Any day, any slot, Malad.
After 5.
Malad, I don't have a problem. I will appear.
I do never change. Mr. Das, I do never change.
September. But everything I am telling you after 4 is tentative. Everything is tentative. That is your item. 8 তারিখে করলাম।
390, Lordship will Lordship had fixed it at 4. But today again there is a 3:30, my lord, and I'll be my lord ousted from my house on my lord 3rd, because 3rd is the auction. So my lord, any day before that, kindly my lord. Well, I had agreed to my lord, but today also there is a 3:30. I can't, my lord.
That is why I've kept it on a Thursday.
Nowadays Thursdays are also risky, my lord. Depends upon the weather.
This is the difficulty, Mr. Banerjee.
I understand, but my lord, I am in dire straits, my lord. Third is the auction, my lord. They have advertised even during the pendency. 3rd is the if. Is there, she has mostly completed. She'll make her submissions. I don't think, but Lordship had one query. That is why my Lordship had kept it. The auction, my lord, in terms of the advertisement.
2 তারিখেই রাখুন তো 4টের সময় রাখুন তো। Second.
390. Second at 4. 3:30, may I come back, my lord? Because next day I will be outstayed, my lord. I can't, my lord. Grateful.
Yes, call the list.
390. 390.
Number 48.
I appear for the petitioners, my lord.
I'm for the opposite party.
Yes.
Although my learned friends were not on caveat, they have appeared, my lord.
Not in caveat.
You have served a copy?
No.
No, my lord.
You have not served a copy?
We were not on caveat, my lord.
We were not on caveat, my lord. But I had requested him for a copy, but then he was of the view that after the hearing, he possibly would, depending upon the
will,
order,
of
give
course,
me a
sir.
copy.
What is the application?
I have assailed an order dated 5th of August 2025, my
Yes,
lord.
what is the nature of the order?
The nature of the orders, my lord, an application under section 151 of the code was preferred by my clients seeking clarification and a modification of an order. That application under 151 has been directed to be kept in abeyance and the suit has been directed to proceed.
Where is, what is the order which you prayed for modification?
Yes, my lord, may I very briefly place the facts?
Yes.
The plaint, my lord, will find at page 52. This was a suit for declaration that a notice of AGM was bad. The petitioners, my lord, are the plaintiffs before the learned trial court. They are the members of a society. And
you give her a copy. Please give her a copy.
I will serve. My lord, one difficulty is the order states, the order against which I have sought clarification states that there is a special officer that has been appointed in this matter to prepare electoral rolls on the basis of which the election is to be continued.
Yes.
The special officer himself, on his advice, we have approached your lordship's court city. So I beg your pardon, my lord.
Give her a copy.
I'm praying for stay, my lord. I'm praying for a state. Because the special officer has to prepare the roles, my lord.
Yes, yes. Let him start. Nothing will happen.
Absolutely.
We will learn it.
obliged, deeply
My lord,
obliged.
may I be granted leave to serve it to the learned advocate?
Yes,
Yes, yes,
I
I've
will take,
said.
I will
Obliged,
take up
Learned
action.
advocate.
Deeply obliged, my lord.
49 from the learned advocate on record,
Yes.
not the arguing counsel.
49, my lord, I am
Obliged.
deeply obliged.
Yes.
I'm praying for a short passover, my lord. I am led by
Item
Mr.
number?
49, my lord. Short passover.
Yes, yes.
Well, Mr.
What
Doc-
passover?
Mr.
Why?
Sukanta Chakraborty is appearing for the petitioner. He is on his legs, my lord. Very short passover, my lord.
Obliged.
Very short passover, my lord.
Passover, next.
Item number 15, I am praying for the petitioner, my lord. Not open the file, my lord. What I pray, my lord. What I am praying today before my lord is, my lord, I have challenged an order, my lord, arising out of section 47 rejection. My lord, but today now, my lord, I am praying, my lord, kindly gives me a breathing space. My lord, I am ready to deposit an occupational charge. My lord, this is with respect to shop room. Eviction order has been passed.
No,
Now-
occupation charges, appeal is pending.
No, my lord, appeal has been disposed of. In the appeal, I was directed to pay, my lord, 5,000 per month as occupational charge. Now, my lord, in execution, my lord, police help has been filed. My lord, I am beseeching my lord to grant me time to vacate the premises.
You want to vacate the
I will
premises?
vacate it.
Already.
My lord, but
So
come
when
time,
you will vacate?
my lord, my client instruction is, my lord, this is an shop room where, my lord, the irons and, my lord, that hardware materials are, my lord, kept. My lord, I have a space for shifting, my lord, and, my lord, there is an eviction suit on that space also. I have filed. My lord, so that suit is at the final stage, my lord. A year if may be granted.
That is ifs and buts.
No, not ifs and buts, but
undertaking
that is, my lord, within 2019. Within, my lord, 1 year. For 1 year, I will pay him occupational charge as directed by the appeal court, 5,000. That was not very far, my lord. I will pay him.
Vacate within 1 year,
My lord,
you will file an affidavit.
My lord, it will be, maximum 6 months, my lord. Because since
I
2019,
can wait
I am
for
waiting.
6 more months, my lord. I can make an alternative arrangement and, my
6
lord,
months you can make. So Chatterjee, do it by 6 months. 5,000
per month.
per month. You will not let out. You will not
No creation of
damage.
third party interest.
File an affidavit to that, Mr. Chatterjee. Don't take it on your shoulders.
Yes, my lord.
So you file an
If it makes it
affidavit.
returnable, I will call my client, give an affidavit and undertaking before
Yes,
this
I'm
court.
fixing this. When is the execution
My lord,
date?
police help has been heard out. It is fixed for passing orders, as I am
On
told.
when?
My lord,
My
date
lord,
has been
18th of August was the date fixed for order. Order has not been passed.
18th
What is the next date? Any date has been fixed? No.
No, as
So I'm staying it for a limited period. So you file within a week.
My lord, my undertaking may also be.
I will record his
my lord
submission.
records.
Yes.
I will record his submission. He will file an affidavit.
Yes.
Uh,
On condition of
Yes,
filing.
he will,
5,000.
with the condition that for this period, he will be paying occupation charges at that rate. He will not part with, he will not
No.
damage,
No, that
nothing
will be there.
he will do, and he will vacate. 6 months is
My lord, next year, February, March.
February.
Well, let it
End
be
of
March.
February.
Let it be March.
This-
One more month, my lord, nothing will, heaven will fall. But I may
Convince him.
conclude my suit. there.
2019, I am
Convince him.
2019. Tomorrow এক মাসের জন্য কি-
I am barely submitting, my lord. He has considered. He is just obstructing because that suit, my lord, he
Months
will.
is reasonable, Mr. Chatterjee, to shift. If you cannot shift with 6 months, you
It's not
cannot
about
shift it.
shifting only, my lord. It's that if I get my property, which is under tenancy, my lord.
Mr.
then, my
Chatterjee,
lord,
that's ifs and buts. You cannot, if you get that, you can shift that because I think you have decided where to move in the meantime. So do that. If you get that, you will be moving there.
Very well.
Because you know how much he had to suffer for to evict you.
Well,
So-
I understand, but
so your-
because genuinely,
Your tenant will also put you in that.
absolutely, my lord, the tenant himself says, my lord, understand his peril, but my lord, I am also peril. So this period, if can be granted.
Yes, 6 months is. After this application under
kept on it.
Yes, yes. Next.
Item number 51.
Yes.
I
Yes.
am for the petition, my lord. Eviction suit, eviction of a license.
Opposite.
Caveat lodged a sub copy. Eviction license, my lord, the original tenant expert and this the present petitioner substitute tenant. They make an application at the stage of argument that some documents before the license there was a tenant who signed his tenancy handed over all the documents.
So what is the suit for?
Suit for eviction of a licensee.
You have filed a suit. You are the
No,
plaintiff.
I'm the plaintiff.
You have
Substitute
filed a suit for eviction of a licensee.
licensee. Now, my lord, some
What is
documents.
the defense case?
Defense case is that, my lord, previously there was a tenant in respect of the same premises, a shop room, a stationary shop room was there. Now, after 5 years, petitioner allowed the opposite party to run a sweetmeat shop. Now, he is claiming he's a relative of the original tenant. They are owned by Mr. Khadala. Therefore, their relationship, they are also tenant. That is the case. Now, my lord, some documents when the original tenant handed over the tenancy, handed over some documents. Those documents are not submitted at the time of adducing evidence by the plaintiffs. Now, at the stage of argument, they made an application on 151 to submit some document. Those documents, that is the original tenant receipt, rent receipts, and trade license in original. That is a rejectable learned court saying that under 151, that is not the provision. Under 151, that document cannot be submitted. Specific provision is there.
Yes. Specific provision is there.
Yes, my lord.
So then what happened?
Another application filed 1817A.
17A has been deleted.
1817, sorry, 1817.
1817 is the court's requirement. The party's requirement.
Yes, my lord. Now, 1817 application filed, learned court held no earlier occasion, you have filed the application, I have rejected, therefore this is not maintainable.
This is not maintainable.
Yes, my lord. Lordship, can you see order number 22, 12 August, dated 12 August, the second order.
No, so that was rejected.
Rejected.
So it is application filed by him.
Not by me.
First, my lord, he filed an application under
And
section.
You are the defendant.
I'm the plaintiff. Petitioner.
Why did you file this application?
Because, my lord, the earlier tenant, when surrendered this tenancy, handed over some documents, rent receipts and trade license, etc. Now, subsequently, we allowed the opposite party to use the shop room, not for money, as a licensee. Now, my lord, evidence.
So you have filed a suit for eviction of a licensee. Yes.
Now, my lord, at the stage of argument, the original plaintiff died. We are the
Original plaintiff died, yes.
We are the substituted plaintiff.
Yes.
Now, we got some documents from the custody of the original plaintiff in a tank, some rent receipt in original and a trade license in original. Now, to establish a case that the original tenant handed over the tenancy or signed the tenancy, we make an.
That was not your case. That was not your case.
They are claiming, my lord, that they are.
Show me your case. You cannot be permitted to lead evidence which is not the case made out. Show me that you have made out that case of tenancy, earlier tenancy, thereafter. Where is that case made out?
Page 10, paragraph 3.
Page 10, paragraph 3.
Yes, my lord.
Yes, page 10 is paragraph 2.
Paragraph, page 11.
Is page 11.
Yes, 11. Page 10 starts from page 10.
Sitaram Misro, previously.
This is to mention that one Sitaram Misro, since deceased previously was a tenant under the plaintiff in respect of the suit premises in schedule below, and after his death, his son, namely Abhadesh Misro, became tenant under the plaintiff who voluntarily surrendered the tenancy and left Ascension 5 to 6 years back. Now, thereafter, my lord, this
so your case was Sitaram was the original tenant.
No, Chief.
After his death, his son became the tenant, he surrendered. Now this defendant, who is he?
Defendant is Debanand Misra.
Yes.
He was allowed to continue a sweetmeat shop in the same shop room in the year 2005.
Where is that case made out?
Paragraph 2, my lord.
Oh, yes. Friendly relation.
Yes.
Yes. So you have filed a suit for eviction.
Eviction.
Now, where is your application under Order 18, Rule 17?
Page number, my lord, 20.
20.
20. Yeah, 20, the first one.
23, my lord. Order 18.
First one is 151, my lord.
That was rejected.
Rejected.
You have not challenged.
Not challenged.
Both the
No,
orders.
no, here I have challenged.
Both the order, yes.
Challenge both the orders.
Yes, my lord, both the order.
All right, show me that 151.
Page 20. Page 11, paragraph is my lord, 21, paragraph 3. The due to illness of original plaintiff, aforesaid documents were missing and not traced out. As such, the PW1 could file the same at time of evidence. However, after vigorous search out, the present plaintiff found the aforesaid documents and have filed before the Honor's Court.
Yes,
for
so
definitive
you have
consideration.
filed this application to recall.
Yes, my lord.
Shift back
Because
from the preemptory report.
To file the how and to mark, so you have to pay for recall. How you will file these documents?
Recalling, my lord, with recalling, it is
Where?
implied, my lord.
That is not your prayer.
Subsequently, I filed an application for recalling. Order 18 rule 17. Rashik, can you see next one?
To recall, Pradeep Sharma.
Yes, my lord. Page 23. Starts on page 23.
All right.
And that
So
is-
these questions. Now, show me the initial order by which
Yes, it is-
151 was rejected.
It is order number 118.
118.
5th July, yes. 118, 5th July, 2025. To this record is fixed for argument. Both the parties have adduced evidence hard considered. On my lord, kindly see the bottom. On such perusal, it appears that the
And what is their case in the
Yes,
written
saying-
statement?
they are saying they are governed by Mitakhara law. The earlier tenant is the uncle of the present defendant.
So he has become tenant by virtue of inheritance.
That is the point. And we are saying that is not the case. They have signed a tenancy. My lordship, can is the it is actually my lord, from third page, order number 18.
Give me a minute. Yes.
Then my lord, kindly see order number 122, dated 12 August 2025. The second application also rejected on the same score, my lord. The earlier it has been rejected, therefore nothing to be.
No. It was rejected on the ground that you were trying to fill up the lacuna in evidence.
Yes. The first point. The second one, my lord, that's
No, second one, 122.
122.
Here the facts leading to the has been transpired that I have not given any satisfactory explanation why you could not produce this in spite of having custody.
Yes.
So that's the reason.
Another reason.
After a long time,
After closing of the argument of the defendant.
The reason is, my lord, the original defendant custody, the documents are under custody of original plaintiff. And he was due to old age, couldn't remember where those documents are kept. Subsequently, we discovered it, my lord, after substitution.
Yes.
And all these documents are kept under the custody of the original defendant, plaintiff.
By way of filing this appeal, you cannot fill up the lacuna in evidence.
No, I'm not going to fill up in lacuna, my lord.
Yes.
And the point is that
Evidence
documents-
concludes at the argument stage.
Yes.
argument stage, not yet started, argument stage, not yet started, my lord.
Not started.
Not, but my lord, if I have some document, the best evidence. which I have
2009
copies.
volume 4 is against you.
But my lord, recent judgment of K. Velupam, it says honorable court that.
Thereafter, that is 2011-11 SCC. Thereafter, 2013-4 SCC is against you. Bagai construction. That's against you.
But my lord, for the ends of justice should be allowed. This is submission, my lord. Because.
Bagai construction is against you, 2013,
Yes.
considering
Hardly
that.
judged, yes, 2009.
ওই দেখি কি দিয়েছে আপনি দেখি ভরে গেছি Which paragraph?
Yes. What do you say?
Only that, my lord, thing is that, my lord, even your lordship will not find any reference with the plaint, on which the plaintiff wants to rely.
Yes, plain
It is
reference is there. Plain reference is there. That is why I have
Not
checked.
reference, since my lord particular relied upon the plaintiff.
No, but
That portion is not there.
no. Evidence need not be pleaded in the pleadings.
No, I am not saying that.
So the case, paragraph 3, specific case is that Sitaram was the original tenant. He died after his death. His tenant became, his son became the tenant and he surrendered.
Yes.
Now he says he wants to produce those documents with regard to the tenancy of Sitaram and thereafter surrender. He
Yes.
wants to produce those
My
documents.
lord, kindly
So
consider.
pleadings are there.
Pleadings are there, but my lord, kindly consider, recent judgment of the Supreme Court also says the particulars, my lord, which plaintiff wants to rely with the plaint, my lord, that has to be, my lord, annexed to the plaint. That is, my lord, vital one.
That's not mandatory. That's a
My lord, recent
curable.
judgment, my lord,
That's a
Justice
curable
Padriwala.
subsequent stage with the leave of
Padriwala says it's
with
a, my
the-
lord, essential one. Justice
with the
Padriwala
leave of the
said
court,
yes.
that can be done at the
But
subsequent
that
stage.
leave has not been, my lord, during the,
That's the leave. Application is the leave.
no, during the
Application is the
lifetime,
leave which they want.
during the lifetime of the original plaintiff. Hey, my lord, that, my lord, original plaintiff produce evidence.
Yes, yes. Show me the decisions which you are trying to rely on.
That's, my lord. Your lordship is referring 13 for 14 SSU.
Don't rely upon the observations of the court because
No.
I know it very
No,
well.
I'm saying that I'm carrying that.
To use it in which way, which paragraphs. Yes, where is the 2025 judgment? Relying on 2011 has reiterated in 2025 by Justice Pardiwala.
Latest one. my lord.
That's the latest one. Relying on, he has reiterating 2011-11 SCC.
That, my
That's
lord,
the latest one.
that I have to find out, my lord. That is one. But thing that is the particulars, my lord, it has to be, my lord, annexed with the plaint. That provision is there, my lord. Now,
You
Supreme
can
Court has
cross-examine
clarified.
him.
No,
You can
my lord, only one thing that, my lord, when, my lord, stage, already, my lord, evidence of the, my lord, argument of the defendant is closed.
Cannot be done. 2011, where is
Oh.
2011-11 SCC?
After closing of the, my lord, argument of the defense. So, my lord, I have already.
Not after closing of argument.
Yes. So that is.
No. He states that argument has only started.
Yes.
Has not yet started.
No, my lord, kindly
Show me that the argument has been closed. Where do you say that the argument has been closed? Where from? No. Fixed 19th of August argument from the side of the plaintiffs. So argument is not closed.
My lord, give me one minute, my lord.
Yes, Mr. Das, where is the 2025 judgment you have not brought?
My lord, kindly sees the order date at 120. Order number 122.
Order number? Order number?
122.
122.
First under the petition under order.
Yes. Order number 122.
Second paragraph. Defendant
Yes.
filed written objection against the instant petition and submitted that the instant.
Order number
petition is
122,
not
second paragraph,
law in
yes.
fact, it is further submitted that the original plaintiff, namely Phul Kumari Devi, represented through her power of attorney holder, namely Pradeep Sharma, and he deposed as PW1 in this suit.
Yes, deposition concluded.
Deposition was concluded on 6/4/2016. The original plaintiff died on 1/2019. Thereafter, the said power has automatically been seized. As such, video cannot be recalled after closing of the evidence, completing the trial, and at the stage of the argument of the defendant.
Yes, not concluded. Stage of the argument.
So, my lord, I have already disclosed my defense. That is, my lord, 2000, my lord, that judgment says, my lord, 2013. After
13.
disclosing, yes. After, my lord, disclosing my defense.
After disclosing your defense.
That is within, very much within the knowledge of the power of only holder.
2011 is at its
That is
stage.
completely to fill up the lacuna in the evidence.
Actually, there's a lacuna. We want to file some documents. We are not filling up any lacuna. You already stated in the plain, this
Yeah, you
happened
have
and
failed
want
to
to
produce
document
the
some
document.
document. It is not the case we say something and now want to revoke that submission or admission, whatever it may be. That is not the case here.
And order 18, rule 17, only satisfaction of the court. If court says, my lord, it is necessary for the my lord. The court has not said it is no, my lord, that
So
belated
that
speech.
could happen to be
and-
included, my lord.
This application under Article 227
In this matter, I'm applying for the petitioner, my lord.
Yes.
The petitioner are the plaintiffs of the suit for declaration and permanent injunction. Their evidence has already been closed, my lord, and the DW1 filed the affidavit.
What is the impugned order?
Impugned order, my lord. Last page, my lord, plain order, my lord. 34, my lord, page.
Eighteenth of August 2025.
Yes, my lord.
Oh, expunging certain statements from the affidavit in chief.
Yes, my lord. Documents
What is
also.
the provision?
Provision, my lord,
Show me the provision.
at best they could file an application, my lord, for amendment, and or, my lord, that has not been done. Only, my lord,
Where is your application? Where is your application?
application, my lord, page, my lord, 26. 30, my lord, page 30.
30.
30.
What is the so you are aggrieved by the rejection of your application dated 23rd of July 2025.
Yes, my lord, and as on the same date, my lord, their pair was allowed, and
What was allowed?
Their pair for
What was their pair?
exhibit to exhibit the documents, my lord. That has been exhibited without any objection.
You did not raise any objection.
Yes,
Where
my
is
lord.
where is their application?
My lord,
18th of August. Where is that?
My lord, there page 33, my lord. We are going to finish the, my lord. No documents are relied upon, neither relied upon nor filed nor any leave or was paid for, my lord.
This application
For the petitioner, lordship. I'm for the petitioner, lordship.
Yes.
Lordship, this is regarding gross injustice suffered by the petitioner developer, lordship. In view of an order passed by Honorable State Consumer Disputes Resolution Commission, lordship, wherein a joint venture development agreement, lordship, has been wrongly
Consumer Forum complaint case disposed of.
complaint case disposed of, review preferred, lordship. Review has been rejected by a cryptic order, lordship. That is
The complaint case has been disposed of. There is a remedy of appeal.
appeal, lordship. Review preferred, lordship. Review after review, lordship.
After the review is rejected, what happens? It's the original order you have to challenge.
Lordship, review preferred, lordship, as per say, order 43, lordship.
Order 43. What order 43?
43 rule W, lordship.
Order 43.
Review is rejected, lordship. Revision lies. This is my humble submission, lordship. His review is rejected,
If
lordship.
the review is rejected, what you have to challenge?
Lordship,
If the review is rejected, which order has to be challenged, sir?
lordship. Original order, lordship.
So original order is an appellable order.
But review, I have challenged the,
Sir, when a review has been rejected, you have to challenge the original order. Original order is an appellable one. Please move the National Commission.
Well, actually, what happened, lordship? This is a gross injustice suffered, lordship, and
Maybe, sir.
I have come before the lordship to interpret
National Commission is there, sir.
consumer, lordship. Interpret the word definition of consumer, lordship. That is the
Prefer an appeal, you have a very good case on merits. Prefer an appeal before the National Commission, you will succeed there. This application under Article 227 of the Constitution of India is at the instance of the you are the developer, is at the instance of the developer challenging the order being number 20.
May I please, Your Lordship?
Yes,
This matter, my lord, I am appealing for the petitioner.
yes.
My lord, application under section 151 of the CPC for rendering fully self has been rejected. For fully self.
Yes, yes. Police have ad interim temporary what?
Ad interim.
Ad interim.
Ad interim order is there, my lord.
Ad interim police implementation.
My lord, landed judge, my lord, held only because of the fact that order 13 rule 2A is pending. That's why, the same has been.
That may not be the ground, but ad interim order, sir, I have held. For that, police help cannot.
The order is still there, my lord. I'll be showing one judgment of our court, my lord. Your lordship knows that Paresh Chandra Das versus Vikas Kumar Das, my lord.
That's it. That is on status quo with regard to nature and character.
Now, this is
delivered by
this Justice Jyotirmay Bhattacharya.
Yes, yes. Status quo with regard to nature and character.
But
ad interim order of status quo extended from time to time in the presence of the learned advocates for the respective parties. That was on status quo with regard to the nature and character.
But this is not this is mandatory order, my lord. My lord, annexure B,
Yes,
page
what is the
24,
mandatory
27,
order?
order of injunction, my lord.
Where is the order of ad interim injunction?
Injunction, page 24 to 27.
Yes.
24 to 27. Yes, my lord. Operative part is, my lord, 26.
Yes.
That the player is application on order 13 rule 1 and 2 related to section 150 CPC allowed expertise in terms of the observation as made above. The defendants are restrained from.
What is your
creating
allegation?
issues.
What is your allegation?
Allegation, my lord, after injunction, my lord, what they are doing, they are putting mud and murams and, my lord, and changing the nature and character of the land. It's completely, my lord, cultivating land.
Then you are not in possession.
No, I am in possession.
How can they do that if you are in possession?
Well,
if you are admitting that, then you are out of possession.
In my absence,
you are out of possession, sir.
No, I am not poison, my lord. Even, my lord, order 13 rule.
Have you considered my judgment in the case of Halim Mullah?
Pardon, my lord.
Halim Mullah.
Halim Mullah.
Have you considered that? I have delivered a judgment on this.
My lord, I am saying only, my lord. My lord, kindly allow me, my lord. I will serve.
Starting from AIR 86 Calcutta. 220.
My lord,
I have considered all those judgments.
My lord, kindly.
I have held no.
Kindly allow me to serve the petitions of the opposite party. I will come back.
Of Honorable Justice Dotto in 2012, I think CHN also. Where is that? You have not brought those judgments.
Justice Tandon. Then, my lord, kindly fellows, it takes up tomorrow, my lord. I will bring those judgments, my lord.
What those judgments? I have considered all these decisions, including those of Supreme Court, and have delivered the judgment. I am bound by my own judgment.
My lord, if my lord application is moved for before the read code itself civil is pending, civil would be not maintainable. So no, what, my lord, where people will go, my lord?
That is the difficulty. That is the difficulty in that matter. You will be finding initial approach to the read code. Read code said civil code.
Civil code.
Thereafter.
In the meantime, entire land will be approached.
You will understand why. The reasons. And the submission which you are making that they are doing, that means you are out of possession. If I record that.
Now I came back. I have taken possession. When initially they are pouring mud and morams and all. Now I am in possession. I came back. Actually,
initially you were in possession. Obtained an order of ad interim injunction.
No, my lord.
Then they were in possession.
I went for my treatment. I was out of station and taking advantage of my situation. My lord.
How did you take again possession?
I came back. Now I am in Bengal.
How could you house them?
Actually, it is a land, cultivating land. No demarcation is there, nothing, no boundary wall, cultivating land.
Record of rights stands in your
Yes,
name.
everything I have. Everything I have.
When is the temporary injunction application scheduled? I am directing the temporary injunction to be disposed of. That will be better.
Temporary injunction. Haji Mullah to my lord judge.
From your left side.
Your lordship's judgment.
Yes.
That my lord,
Can direct the temporary injunction to be disposed of. I think temporary injunction is otherwise ready.
day by day it's renewing, my lord.
Day by day it's being renewed. I'm not on that. I'm asking you, is it ready? Can I direct the trial judge to dispose of that?
No, no problem. No problem. Huh? No problem. That would be better.
That would be better?
Better.
All right. After some
There is a Passover matter, my lord. Item number 40.
passed over.
My-
Yes, next, call the man.
Item number 381.
I don't know 381, my lord. Your lordship, my lord, this is a very short point. My lord, against the, my lord, state
You are for
consumer.
the petitioner or the opposite party?
Here I am the petitioner.
Petitioner, please come in this side.
I am the petitioner, my lord.
Yes.
My lord, I am on behalf of the opposite party number 2, my lord.
Opposite party number 2.
Yes, my lord.
Yes.
Here you will find.
Yes. Where is the opposite party number 1? Yes.
First one, your lordship, state consumer dispute settled from my lord, passed order on 20th September 2022. Against that, my lord, we preferred, my lord.
What is the impugned order?
Impugned order, my lord, at page, my lord, 179.
179.
179 impugned order.
What is the nature of the impugned order?
Section 5 application was rejected.
Rejected. By?
By National Consumer Dispute Resolution.
By National Commission.
National Commission, my lord. Then, my lord, we moved before the Honorable Delhi High Court. Delhi High Court granted liberty to move before the
Delhi High Court is not the jurisdictional court.
That's why, my lord, Delhi High Court granted liberty to approach the jurisdictional court. We approach your people lordship. And, my lord, only the
What is the period of delay?
227 days.
Only 227 days. It's not much, Mr. Dotto. 227 is not much.
279.
That's right, my lord, to decide, but my lord, for the interest of justice, my lord, the entire medical college has been stigmatized.
How much cost per day? At the rate of rupees 10, 100, 1000 per day for conversation?
My lord, regarding cost, I will not say anything. What your lordship will see fit. My lord, yeah.
What is the reasons for the delay? What is the cause?
Wrong.
Wrong forum. Oh, you went before the Delhi High Court. Sir, that is
that is not the reason.
No, that is not the reason, my lord. I have explained the reason.
What is the reason I am asking you? What is the
page 171? You will also find
171?
Page 171, my lord. The delay has been explained, my lord.
What is the complaint against you?
Complaint, my lord. The complaint, my lord, a patient was admitted, and my lord, the patient was admitted, my lord, and all possible treatment has given. My lord, due to
expired
cancer detected during my lord, tuberculosis problem, admitted, cancer detected, every possible way, my lord,
what happened? Died?
Then my lord, the complaint has been made, and my lord, there is.
So, who are you?
I'm a mother. It's a legal aid matter.
No, who are you?
I am the wife of the deceased gentleman.
Wife of the deceased.
I was awarded, my lord, 10 lakh as compensation, and I've been going round and round in circles. It's come to a finality. My execution case is proceeding. They come with a delay of, my lord, over 9 months.
They have a statutory right of appeal.
Yes, but subject to them having a good ground for condonation of delay.
What is the ground for
Kindly
delay?
see the ground, my lord. No ground made out, my lord.
Page?
Kindly see page 175.
And 175 will also find.
Just one paragraph. This is not the way, my lord, to treat a person like me, my lord.
Filing the present appeal due to the reasons that the advocate who is looking after the case.
Which paragraph? Which paragraph?
Paragraph 2.
Paragraph 2. Had fallen severely sick and no communication was made by the counsel for the appellant for the same. As a result, the counsel failed to appear on the case and also to take steps due to lack of information on the appellants also could not take proper steps.
Mr. Dotto, is it a good ground for condonation? You are a hospital. You are a hospital.
Kindly, for the interest of justice, my lord, my lord, I will not, my lord, cite any judgment. You will also kindly consider it, my lord. I will not cite any judgment that on the part of the, my lord, government authority. There are some lacuna in
The other judgments, other line of authorities are there. It's not a favored litigant.
That's why I will not place any judgment.
It's not a favored litigant. Judgments are on both sides.
I will not place any judgment. I am leaving the matter. You will also kindly fix the time period and fix the time period.
What do you want?
Kindly understand my plight.
I'm expediting this. After all, some case
279.
There are many
279 days delay. No sufficient cause given. No cause given. Well, your lordship has seen the paragraph. Not a single
Doctor, you have to compensate.
not a single document.
You have to compensate because
and see the conduct.
Yes. Please tell me what should be the amount. I leave it to you. Be reasonable. Be reasonable. If you quote a reasonable figure, yes, you can take instructions from your left.
20,000 you also can leave. But 10,000 you also can leave.
10,000, Mr. Rishi, please. Cannot be 279 days.
Right,
270. No, this 279 is taking into account that Delhi High Court also.
Delhi High Court is subsequent.
Delhi High Court is subsequent.
So I've been, my lord, lurching, my lord.
I'm leaving the matter. You also, my lord, regarding my lord.
You are for whom?
Opposite number 2, my lord.
Who are you?
The doctor, my lord, doctor. Who treated the patient, my lord.
So against you also an order is passed.
Yes, my lord.
You have not challenged.
No, my lord. I have not challenged, my lord, but I was ready and willing to pay my half compensation orders.
So you are not aggrieved by this.
No.
No, of course, my lord, I am aggrieved, my lord, because my lord.
If you are aggrieved, you can challenge that. But with regard to condemnation, you have nothing to say.
No, no, my lord. Condemnation, I have nothing to say.
That is what I am
On the
saying.
other hand, I am supporting them, my lord.
That is what I am saying. So you have nothing to.
No.
I'm leaving the matter, your lordship gave me.
2012, my husband passed away. It has been 13 years. I've been running from post to pillar.
I'm directing the appeal because what is to be done? The records are to be called for. What is the procedure? Not for here in the first appeal.
First appeal is before the national.
Before the national court, what is the procedure? Yes, Mr. Datta, what is the procedure there?
The record
Records have to be called for, or
but all records I have enclosed.
you may have enclosed. What is the procedure? Records have to
Procedure,
be
my lord, the entire records will be called for.
from State Commission.
Yes,
This is the first appeal.
first appeal.
I've spent 10 years at the trial court. I'll spend another. I'm not saying anything. And my lord, this is my lord, a person who's suffering, my lord, below poverty line, my lord.
So that is why I'm expediting.
I'm the bread. He was the breadwinner of the family. I'm a lady. I'm in distress. I've succeeded after 10 years. My execution case is pending.
Mr. Medora, that
I know.
clock cannot be turned back.
Absolutely.
So what has happened?
But kindly bring an end to this, my lord. This is the end.
Yes, yes. So I'm directing the first appeal to be
Or
discussed.
let them pay me the money at least. Let me get something at least, my lord. Let them pay me
Mr.
at least.
Datta, only one thing. Even if you pay for stay, you have to, before the first appeal, you have to pay some amount. Maybe you are challenging with regard to that. Can you not pay, can you take instructions with regard to that? With regard to, but Mr. Medora, there will be one problem. If they pay anything to you, then that will be an admission on their part. They cannot challenge that.
Without prejudice.
They cannot challenge that. That will be their difficulty.
Without prejudice, they can pay.
I can direct them to deposit that. That's the other way round.
Yes, that
But,
they have to
even
deposit
then-
in any event in the first appeal if they want to
Even
stay.
then, you will not get the money.
I know, I know.
So that prayer you can make when they file for stay. I'm not granting any stay of this. I'm only allowing the section 5.
There's no infirmity in this order, my lord. Well considered.
What is the order?
Can you see the order, my lord? No perversity, Supreme Court. And can you see the conduct? State Commission also, it was ex-party. They failed to appear. Then they sit again and sleep over their rights. This is not my lord.
What is the impugned order? Which page?
Page 179. Unless the only cause shown in delay in the
So page 179 is the order.
Yes, my lord.
First starts, my lord, the advocate who's.
You have not filed the certified copy.
Yes, I have enclosed my certified copy. I have enclosed the certified copy, you will see fine.
Subsequently fine.
No, separately. Separate file. Well, after that, my lord, we also, my lord, filed an application for review of that conventional bill.
Review of what?
Review of conventional bill. That was.
So this application, after this was rejected, you have filed an application for review.
Yes.
What happened?
That review also reject, then we move to the honorable bill.
Review also rejected.
So can this order be impugned today after the review has come into force?
After the review, they can challenge the parent order also.
But kindly, my lord, it's a reasoned order, my lord. There's nothing perverse, my lord.
Section 5, Medora.
I know. Only thing is, my lord, kindly consider who the litigant is. Kindly, my lord, give me some compensation at least so that I can live a life till I die, at least while the case still goes on.
Yes, Mr. Datta, what do you say to this?
It's a David versus Goliath situation, my lord. Any other client, any other litigant, I would not have said all this that I have said.
What do you say, Mr.
But considering it's a legal aid matter, considering the person is below poverty line, considering the person is unemployed, considering the person is a lady, considering the person, her husband has died, considering it's because of their negligence, they failed to appear before the State Commission, slept over their rights. After 10 months, they again still sleep, and then they come.
Mr. Datta, what do you
Everything points in my favor, my lord.
My lord, your lordship kindly, within 1 month, your lordship kindly direct the. Within 1 month, you also kindly direct the National Commission within 1 month.
They are saying, can you pay for the time being some amount without prejudice?
Client টাকা দেবে।
জজ সাহেব যদি বলে তাহলে দিতে পারবো কি ব্যাপারটা দিতে পারবো
He is also
Want
my
to come back with instructions?
না ওটা তো ইনস্ট্রাকশন হয়নি
তোমরা এই শোনো, তোমরা
That is,
without prejudice.
Malad, only one thing, 10 lakhs has been awarded. That both has to pay, my lord. Both has to pay, my lord. Initially, my lord, I was ready and willing to pay the 50% of my share, my lord. But that was refused, my lord.
who refused?
My lord, my lord, shall I say that? Justice Shiva sitting with my lord has refused it, my lord. But it cannot be bifurcated on that ground.
Has to be
Yeah,
jointly
my
and
lord,
severally.
Huh?
Jointly and severally.
Justice Shobhaschi Bhattacharya has refused, my lord. Against that, I prefer an appeal that I am ready and willing to pay my share. That was refused by the Honorable Division Bench. And my lord, Honorable Division Bench has also asked me to approach the client, approach the accused victim person. My lord, I approached, my lord, but they did not care, my lord.
Mr. Datta, can it not be solved? Because he is ready and willing to pay 50%.
If he ready to, that's why even he has made.
He says that he is ready and willing to pay 5 lakhs.
Well,
So the order is
But
10
once
lakhs.
for all, but
without prejudice to the rights in the appeal.
my lord, only one thing, if I pay,
No,
my lord, if I
not
pay,
on that. To end everything, can it be done something? Can you take instructions and come? If this can be, entire thing can be resolved, that is what I'm saying. Because he is ready and willing to pay 5 lakhs. So your liability is 5 lakhs. So can it be done anything? Can you take instructions and come back? Otherwise, this litigation will go on.
Only one
Nobody knows where it will end.
There is a, my lord,
After all, her husband died. Maybe you may or may not be at.
but your lordship, my lord, there is the, my lord, if my client admits, well, there is no manner of negligence on the part of the medical college.
Mr. Dotto, if it is resolved, no question of admitting anything. If the entire matter can be resolved, I am telling you.
If my client, if my friend,
well, the medical report says that there is no negligence, medical report. The patient was suffering from comorbidity, that cancer at the advanced stage. And the medical report specifically stated that there is no negligence on the part of the medical college or the doctor.
The evidence I will show that there is
Well,
no
that is the thing.
Their evidence they have admitted.
But that's the problem is if I've admitted the 5 lakhs rupees I think. Second one, if I have a criminal case will be filed.
Criminal case, no, criminal case if it does not proceed with, no.
No, I don't think there is any criminal case.
No, that, Mr. Medora, is your client willing to?
I don't think there is any criminal case pending, subject to correction. After 12
Mr.
years,
what Mr. Boise is saying,
No, that
that after that, if you proceed against him criminally,
Given the undertaking.
then both of you take instructions and come back. If he provided Mr. Dotto, you are willing to pay your share without going anything with regard to those.
Regarding my share, my lord, I submit that if you also examine the entire matter.
Mr. Dotto, that's one part. That's on merits.
right,
I am saying not on merits if this can be resolved. That is what I am telling you.
When my learned friend is
He is saying he will be paying his share.
And on condition that I should be exonerated, my lord, from the case.
Yes, I think if he is interested in any criminal case pending against him, no. That Mr. Medora will take instruction. If they pay without anything, should not proceed against them.
My instruction, my lord, that medical college has got no manner of negligence in the matter. If my client, it is the government money, my client
That's
cannot.
the difficulty.
It is a government.
It's the government thing. It's maybe a difficulty.
Well, also there is a
for
judgment.
them to admit something
Well,
because
admission. This is like a settlement, my lord. It's like the lordship referring the matter to mediation and the parties arriving at a
are
settlement.
you agreeable to go to mediation, Mr. Dotto? I can send it to mediation.
My lord, we will not solve this
If
problem.
you are, yes. Are you, all of you are ready and willing to go before mediation?
Will not solve the problem, my lordship, and my client's instruction, my lord, my client's instruction, my lord, my clients has not committed any manner negligence in the manner. There are the evidence.
That is Mr. Dotto on merits.
My lord,
That is on merits in order to put an end to everything.
if my learned friend is satisfied with the 5 lakhs they are paying, then my lord, I have nothing to say.
No, but you will not pay anything.
Well, I have not committed any commit in any way.
Then he will not be ready and willing to pay.
No, Malad, that is a difficulty, Malad.
But you say that
because
only
Malad,
he will pay,
because
I will not pay. Why you will agree, Mr. Tattva?
limits supposed before the division bench. When I was ready and we expressed my readiness and willing to pay.
My client is not ready or willing to pay the compensation amount, but this is government fund, who will pay? The principal is not entitled to make any payment. And the health department, I have to.
Section 5 is rejected, then you have to pay, Mr.
Right,
Tattva.
but.
Then you have to pay.
With interest.
Before lawsuit, I.
Then everything.
But I pay people lawsuit that if the matter, you lawsuit, hard to matter on merits. You lawsuit will find that there.
I cannot, Mr. Tattva, I cannot enter into the merits of the matter.
You lawsuit.
I cannot enter into the merits of the matter.
Right, but considering this aspect, my lord, you lawsuit kindly, there is no benevolent fund from the medical college. I cannot.
No, what for? No. Instruction. Instructions, if you want to take after that, I will.
That's very clever, but no.
After conversation, what instruction he will take?
It's very clever of my learned friend, but no.
Before the consumer, before the national forum, you will also kind of direct them to expedite the matter within a month or within.
That doesn't happen. I know that. I've done so many matters there.
as transmit by way of electronic transfer. So please furnish all the particulars, IFSC code and other things, what are required.
Yes.
কি বললেন? Wait, quick.
Yes, yes, immediately.
Though I have given 2 weeks.
I will try within 1 week.
Please, you are there, Mr. Bhoishi is
yeah.
also there. If both of you try, it can be,
I
I
will try
think, within a
1
week, it can be done.
And my lord, the interim order already passed. That will, my lord,
What is the interim order?
interim order, my lord, stay of execution till November. That will continue so that I may be.
Stay of execution till November is there.
Yes.
Yes, I'm passing that till November thereafter.
Yes.
The
8, my lord,
the Our CO stands allowed.
Item number 341, it was 3 PM matter.
341.
341. Along with that, there are two matters. 340.
Boishi is here. He will curse me if I continue.
Well, what I'm submitting, Lord,
But
340 should be
submit before you, Lord, if the Lord's a matter 330,
341, 341.
Lord's you have
No,
promised
no.
the matter will be taken up
Mr.
350.
Boishi, you have compelled me to take this matter. Yes, in this matter. This matter started at 325. It's only for you.
There is no objection at all, Lord's in our side. Matter will be taken up at 325. If the matter will be going on 6 or 7, there is no objection, Lord. If the matter will be taken up after 330, then Lord's I will not present before you.
Lord, what I am submitting, my submission is very small, Lord. 340 and 341, both matter was mentioned. One is against the doctor, one is against the hospital. And
In
both
this
are
matter,
341, I'm saying.
I appeared for the
So
opposite party.
340 and 41, only 41 has come.
it
But
is also a consumer
yeah,
forum.
yes, ma'am.
No, not this matter.
Not this matter. 340 has not come, but 341 has come. So both should be had together.
Can you asini? Accept.
341 is
It
marked.
is in the list, it is in the list, but not, it was not mentioned. We're only the
Chaturvedi,
only
the
problem, the state commission
that motions are there. What can be done?
Only,
Lord, I
only
That's
problem
the-
which
that's
I am
the only
facing, Lord,
difficulty.
one problem I am facing, Lord, the state commission.
You are the complainant.
I'm the appellant.
You are the complainant.
I'm
the
hospital.
complainant.
The
The
execution.
Commission has affirmed the award of compensation in favor of the husband. The wife died in course of a
That
cesarean.
is different. I will argue on that.
No, so now he has challenged the appellate order
Yes,
Yes,
in 227.
yes.
both the hospital challenge and doctor challenge. So why, what I am submitting, Lord, the execution case is going on. So next date is on 9th of September. So if it is hard prior to that, Lord,
Deposit the amount, secure the amount,
I mean,
I will pass an order of stay.
so
Secure the amount, I will
so
pass
far,
an order
so
of
far
stay.
I am concerned, I am.
You need not pay them.
No. So far, Lord, I am concerned, I am the hospital, only 5 lakhs have been deposited.
Deposit that.
What I am submitting.
Who is the doctor?
Lord,
Doctor
Who is-
340, which my learned friend is
Who is
mentioning.
appearing for the doctor?
doctor is, Dr. Soumitra Kumar, he is 340.
Who is the learned advocate representing the doctor?
Yes,
He is learned advocate. He mentioned 340.
Only Chatterjee.
You take instructions, you secure the amount, I will pass an order of stay. I don't think Mr. I will not hear the objection of Mr. Chaturvedi. You
That is-
secure the amount, I will pass an order of
Let
stay.
the lawyer of the doctor let him come. He was
The
so long, he was
doctor is
here.
in your control, sir.
Hence, he
Doctor is in your control. The entire hospital is in your
If the
control.
doctor pays the 15,000,
Lord, my
15
learned friend was mentioning doctors.
15 lakhs have been awarded against the doctor.
Jointly and severally liable.
No.
Doctor is also in your control.
And my,
Within your institution.
no, my lord,
Doctor is in your control. So if you want, the doctor will also pay. Secure the amount, deposit this amount.
doctor's lawyer come, I will tell him. He was so long here. Only Chatterjee is appearing for the doctor. He was so
So
long.
Aniruddha Chatterjee is appearing. He is a busy counsel.
He was, no.
He will not be available before the vacation.
This guy was so long here. So anyway, if the matter,
Right time he has fled away.
he was so long here.
That this will be the response of the court, he has fled away.
He is busy making his own 20 lakhs.
So anyway, as you
Doctor is also in your control.
No, doctor is not in my control because the patient, the doctor is
in your control.
He's the
His doctor is in your hospital. What are you saying? He's not in your
He is
control.
not an employee of hospital. He is just a.
May not be employee.
He was-
He is a visiting consultant of your hospital. Don't say all these things.
Anyway, my lord, your lordship, kindly fix it up on Monday or any subject.
That will be taken up. Please take instructions. If you say that you are ready and willing to deposit that, I will pass an order of stay on mentioning. Please intimate Mr. Chaturvedi with regard to that.
That's security.
Mr. Chaturvedi, if the deposit stay has to be granted.
Whatever my lord pleases.
Okay, my lord.
Oh, my lord.